Good evening, friends. Myself, C. Raj Chawla, welcome you all in this today webinar on how to draft appeals under income tax and GST. And today we are very honored to have two very senior chartered accountants and expert on income tax. CA Asim Chawla ji, a very renowned international speaker on direct tax, and a very senior chartered accountant, C. R.K. Bhalla ji. He is GST expert and he has written various books on GST and service tax. Also, we have young and dynamic faculties for today webinar on GST. We have with us CA Sarthak ji. Welcome, Sarthak ji. And on income tax drafting, we have CA Pranshu Goel ji. Welcome, Pranshu. In these words, now I request CA Asim Chawla ji, our keynote speaker on today webinar. Even yesterday he had webinar on new scheme of reassessment, which is declared in this budget 2021, and rather I have requested him to please take some faceless assessment how practically this will be possible. Next week we will take on my request and equalization levy also. So now I request Asim Chawla ji to please start his deliberation. Sir.
Thank you, Rajji. Thank you, Mr. Bhalla. It is a very humbling day, 19th of February 2021. I will certainly note in my diary for this year of being able to spend time with two very illustrious young Pranshu and Sarthak, who have trust me a great future ahead in terms of reaching the zenith of the practice. So I'm very elated. It's rather very humbling and very thoughtful of you, Rajji, to have asked. I feel really honored. Thank you, Mr. Bhalla. Now, today's subject, drafting of appeal, and if one were to look at it purely as a tax litigator or as a tax lawyer, now the the irresistible thought which would come in the minds of people who are in the practicing community, or for that matter in the taxpayers, is that faceless might be just the game changer. uh, yes, it may have a bearing on how the entire appellate process would pan out, but the fundamentals still remain the same. I mean, you can't be a good T20 player if you haven't gone through the Wisden's cricket manual, because these days cricketing parlance are in fashion. So that is how I would say. Of course, I'm sure the audience, like me, are more keen to hear from Sarthak and Pranshu. I'll be very quick in my thought process. Drafting of appeals. So, first and foremost, make sure that your brief is well prepared. I mean, good beginning is half done. What are the issues involved? One, facts which are relevant, basis of claim, whether it's a case of disallowance, addition, add back, डिनायल ऑफ एग्जेम्पशन, क्या कारण से असेसमेंट हुई, एडजस्टमेंट हुई, what are the reasons of rejection assuming the order is slightly speaking, and then once you present and then get an opportunity for a rejoinder, assuming there's a remand report sort of a situation, do you get an opportunity to make any rejoinder? And now this is purely in the parlance of any litigator. So delegates will bear with us. Now, once you've gone through the brief, then comes the importance of facts. Remember, the great late P.C. Sharma, who was Doyen of our tax tribunal bar, said, and he used to often say, and in my uh, early days, and the days of learning will never end. And when he used to find this 20 odd year old young person in the corridors, he would call me and say, Asim, remember, pehle fact, fir act. And that one liner still resonates in the mind of all of us, the importance of facts. Whether AO has relied on presumption, is there a case of conjecture, may, shall, would, or there are some facts which have been brought on to the in the order, then the difference between preponderance of probability or possibility. Then comes statement of fact. Now, to me, statement of fact should be neutral and not argumentative. I'm sure Sarthak and Pranshu will take the deliberations on this in extenso. I am reminded of what John Davis said, and I quote: I cannot too often emphasize that in any appellate court, the statement of fact is not merely a part of argument, it is more often than not the argument itself. And Judge Carl Levelin said that it is tried amongst good advocates and practitioners that statement of fact can and should produce the conviction that there is only one sound outcome. और वो outcome क्या है कि मेरी अपील जो है और जो मेरा दलील है that should see the light of the day, वो कार्यान्वित होनी चाहिए. After that comes your mission. Don't make it very repetitive. Then comes burden of proof. Remember, burden of proof of facts is always on the taxpayer, and that is the strength of a practicing chartered accountant. The way a chartered accountant can marshal the facts and bring the right facts onto the table, and that's the great asset and quality which a chartered accountant has. Burden of proof on law, friends. The Supreme Court in Deputy Commissioner versus Travancore Rubbers 220 STC 520 way back said that it is on the tax department, on the revenue. So when it comes to burden of proof on law, that job can be well addressed by the department, and if they don't address, we should thrive on that folly. Lastly, when you are drafting the grounds, avoid multiple grounds. उस समय तो हम लंबा बना देते हैं, we get carried away or we are a little enthusiastic about it, but when it comes to actually putting it together, and remember in the faceless regime lot of emphasis would be on drafting. What do you pen down on paper? Clear, concise, crisp, unambiguous. So these are few thoughts. I would rest my opening remarks with one quote which the great jurist Benjamin Cardoso. All of us who are students of law have read Cardoso in our subject. And Cardoso said that one must heed that the margin is not exceeded. Issue was कितना लिखें और एक सेंटेंस को कितना लोड करें. उसकी भूमिका में, in that background, Cardoso said that of course, one must take heed that the margin is not exceeded, just as the physician must be cautious in administering the poisonous ingredient, which magnified will kill, but in tiny quantities will cure. On the other hand, the sentence may be so overloaded with all the possible qualifications that it will tumble down of its own weight. अगर हम लंबे लंबे सेंटेंस बना दें और वो however और notwithstanding and therefore, जब तक वो सेंटेंस कंप्लीट होगा, one would completely lose the track. And this is what Cardoso said, that the sentence should not be so overloaded with all the possible qualifications that it will tumble down of its own weight. With this, I will rest my opening remarks. My heartiest congratulations to Sarthak and Pranshu for this yeoman initiative, and I wish them many more like stars. They will and should continue to shine, and I look forward to many more occasions of fellowship. Rajji, your platform is doing a consistent job as a true child of son of Saraswati. You are doing this knowledge dissemination programs. With this, I hand it over back to you. My best wishes to both of you, Sarthak and Pranshu.
Thank you so much, sir. Thank you.
Thank you, sir. Now I request C. R.K. Bhallaji to please give his opening remark about drafting of appeal under GST. Sir, please unmute yourself. Bhallaji, unmute her.
Thank you very much, Raji. I'm so happy to see you, Shiv Chawla ji, Mr. Goel and Garg here today. And this topic is very important as relating to the drafting of the appeals, because sometimes we miss the very important issue in the case, and we don't take on the grounds of appeal. And we must understand that Article 265 of the Constitution of India, it applies to all tax matters. It says that taxes not to be imposed save by authority of law. No tax shall be levied or collected except by authority of law. So first of all, we must see in all tax matters whether the assessing authority has authority under the Act to impose a tax on us or not. And further, this right of appeal is a creation of the statute. It is not an inherited right of the person to go on appeal. This right is provided in the statute. According to that, it has to be filed in the appeal. When appeal matters are coming up, that it is important because a person is aggrieved by the order against which he is going to an appeal. And while drafting this grounds of appeal, we must take care that we should cover all the points which we want to argue in the appeal. Sometimes what happens, we forget certain points to mention in the grounds of appeal, and subsequently, when at the time of arguing the appeal in the tribunal, we suddenly remember that this point should have been taken, and it has not been come in the grounds of appeal. Therefore, tribunal member may object, sir, you have not taken this point in your grounds of appeal. Therefore, this was a case in CIT versus Western Rolling Mills Private Limited, 154 ITR 54 Bombay. Then they said, the additional claim for the first time, if you want to raise before tribunal, it can be raised if there are evidence or material on record already, but you have failed to take certain grounds of appeal in your grounds of appeal. Then first time you can take up this matter also. So my submission in this matter is that while drafting appeal, utmost care should be taken. And we have with us today a learned speaker on this, Asim Chawla ji. We will elaborate on this issue. And I have this is saying is sometimes additional grounds we have to take. That we should follow Rule 46A in the income tax rules, while we have to take the additional grounds of appeals. And sometimes we respondent can support the order of the CIT appeal by taking any ground, though no cross objection had been filed. This has been said in Cable News Network LLP versus Assistant Director of Income Tax, 36 DTR 233, Delhi. So there are other issues which one should keep in mind. Well, we should keep in mind. And but I feel we should take a common ground, one common ground, that say on the facts and in the circumstances of the case and in law, the assessment order violates the principle of natural justice. This ground do attach in every appeal because it has a very wide concept of principle of natural justice has been violated. That will cover your unleft matter also in this clause. Thank you very much.
Thank you, Balaji, for a blessing words to our young speakers on today's webinar. So now I request CA Sarthak Garg on drafting of appeal under GST law to please start his deliberation. Sarthak ji.
Sarthak, some thoughts for you, and I will also seek or beg your and Pranshu and Mr. Balla's leave. As we are looking towards GST, I mean, and litigation is knocking the door, and I know you are ahead of the curve in your substantive learnings on issues, classification, computation, and the application of rates. If that is something which you could show a little bit of, as a thought leader, in terms of the light which you expect things may pan out. And similarly, Pranshu, before I leave, if I may were to take indulgence, since you have a great wholesome now experience of looking at international tax, transfer pricing, and such matters, how do you individually, tweak your thought process. I think with your great learning and the amount of experience which you and Sarthak bring onto the table, I'm sure that will be a great value add for the audience today. I wish you all the best, and I just would seek your leave if I were to leave in the middle of your deliberations. I'm sure I'm not going to disturb both of you. All yours.
Sarthak ji, please continue.
Thank you, Raj Chawla ji, Asim Chawla ji, and R.K. Balla ji. And I would like to thank C. Raj Chawla ji for such a kind introduction. So you have been very kind in allowing professionals like us to share the little knowledge that we have on your illustrious platform. So I would also like to congratulate your fellow team members for organizing seminars consistently on important issues during these tough and awkward times, and helping in imparting knowledge to all the professional colleagues and the participants from the industry. So, so I've been asked to deliberate views on a very important topic and a practical topic of appeals under GST. So the appeals provisions under GST are detailed and descriptive, and I will try my best to deliberate the same during the next 1 hour. Thereafter, CA Pranshu Goel ji would deliberate his expert views on appeal provisions under the income tax. So you all must be aware that in today's business environment, it is next to impossible for taxpayers to shy away from tax litigation either under direct tax or indirect tax. So in the past few years, tax litigation has sharply increased on account of various factors such as complex business transactions, frequent amendment in the taxation laws, and the aggressive approach adopted by the tax authorities. So, under the taxation laws, on any given set of fact and laws, there can be different opinions or viewpoints. So, therefore, it is likely that the taxpayer may not agree with the adjudication order passed by the adjudicating authority. Similarly, on the other hand, the department may also not be in agreement with the adjudicating order in some cases. So it is for that reason that an enactment provides provisions of appeal to both the sides, that is the taxpayers and the tax authorities. So, however, it would be apt to note that right to appeal is a statutory right, and the provisions of appeal under an enactment also places reasonable fetters on such statutory right. So, in this regard, there are certain timelines provided by the enactment for filing of appeals and the mandatory requirement of pre-deposit of a certain sum before an appeal can be heard by the competent authority. An act also provides that an appeal or rectification or revision or review can be filed against an order passed by a competent authority. So the term appeal is not defined under any act or under the GST legislation, and therefore reference can be made to various dictionaries in order to understand the exact meaning of the term appeal. So as per the Webster's dictionary, an appeal is a legal proceeding by which a case is brought before a higher court for review of the decision of a lower court. Similarly, as per the Collins English Dictionary, an appeal is an application or resort to another person or authority, especially a higher one, as for a decision or confirmation of a decision. So also, as per the Oxford Dictionary, an appeal is basically an application to a higher court for a reversal or the decision of a lower court. So therefore, it can be construed that the term appeal means a request to aid or help which is made to a higher authority to review and change the decision of the lower authority. So it is basically a process for requesting a formal change to an official decision. So it would be hard to note that appeal provisions are generally incorporated under all the enactments with the main purpose of getting the order of a lower authority challenged before the higher authorities for cancellation or modification of the order. So the appeal mechanism works on the principle that any order of the appellate authority shall be binding on the lower authority. So before discussing the statutory provisions of appeals under GST, I would first discuss some important legal aspects with regard to appeals. So the first important legal aspect while drafting appeals is that it is important to note that the right of appeal gets vested immediately as soon as an incorrect decision is made by an authority. So such rights are vested immediately after the initiation of the adjudication proceedings. So the right of appeal is a substantive and a statutory right and not merely a procedure. Such a right cannot be negated or be taken away from the aggrieved person. So there are a number of cases which have been decided on the right of appeal of the SSE and also the importance of this right. So it has been clearly defined by the Honorable Supreme Court in number of cases that the right of appeal is a matter of substantive right and not merely a matter of procedure. And this right becomes vested in a party when the proceedings are first initiated. So therefore, a right of appeal cannot be taken away except by express enactment. So an intention to interfere with or impair with such vested right cannot be presumed unless such intention is clearly manifested by express words or necessary implication. So therefore, the right of appeal is a creature of the enactment and it can never be termed as an inherent right. Appeal right is conferred by the enactment, but one important thing that is to be noted is that while conferring the right of appeal, the enactment may impose certain restrictions such as time limit to file an appeal or pre-deposit, and such limitations are to be strictly followed. So therefore, an important aspect with regard to appeals is that right of appeal is a substantive one, which gets vested immediately as soon as an incorrect decision is made by the competent authority. So another important legal aspect related to appeals is that who is an aggrieved person. So any person who feels disappointed with the result of the case is not a person aggrieved, but he must be derived of a benefit which he would have received if the order had gone the other way. So the order must cause him a legal grievance by wrongfully depriving him of something, and the party shall be called to be aggrieved if its pecuniary interest is directly affected by the adjudication and one whose right of property may be established or divested thereby. So it is important to note that the right of appeal is provided under various enactments so as to provide the aggrieved person a shelter of natural justice. So in this regard, the apex court has laid down the principle that a person who has entirely succeeded before a court or tribunal cannot file an appeal solely for the sake of clearing himself from the effect of an adverse finding or an adverse decision on one of the issues, as he would not be a person falling within the meaning of the person aggrieved. So moving on, the next important aspect with regard to appeals is the term order. So the term order is a synonym of a judgment or a decree. It indicates some expression of opinion which is to be carried out or enforced. So it is basically a conclusion of a court or an authority or the tribunal. So the order implies the finalization of a decision or point in issue. So it is important to note that an order is an important direction or command which is delivered by a court or a judge after an adjudicating hearing. So an order is a formal expression of the conclusions arrived at after verification of the facts of the matter in dispute. So it is pertinent to note that any order passed by the authority shall be a speaking order, meaning hereby that the order shall contain the reasons behind the order specifically and clearly. So this will enable the reader of the order to make out that it has been passed after due care and understanding of the fact of the case and also the prevalent law. So however, no proper reasoning against a decision cannot be termed as an order. So if an order is passed without any proper reasoning, then the same would be presumed to be bad in law. So as discussed earlier, the right of appeal is a statutory right, and the provisions of appeal under an enactment also places reasonable fetters on such statutory rights, such as mandatory pre-deposit of a certain sum, before an appeal can be heard by the competent authority. So therefore, if the right of appeal is subject to a condition like pre-deposit of duty, then right of appeal can be exercised only subject to such condition. So it is also important to note that such condition of pre-deposit has been valid, but can be waived by the courts by filing writs only in cases where there is undue hardship or in case of special circumstances. So further, it is a settled position of law that if an enactment granting the right to appeal prescribes a time limit for filing appeal, then appeal must be preferred within the prescribed timeline. So therefore, अगर कोई भी timeline prescribe करी गई है किसी भी act में, so and वो एक mandatory condition है, so that has to be followed by the aggrieved person for filing the appeal. So, however, the appeal provisions may also provide power to the appellate authority to condone the delay in case of filing of appeal. So, such delay can only be condoned in case the appellant was prevented by sufficient cause from presenting the appeal within the prescribed timelines. So, therefore, mandatory pre-deposit and prescribed the timelines under an act is a very important legal aspect that has to be taken care of while filing appeals. So moving on, one of the most important aspects with regard to appeals is cross-examination. So cross-examination as per various dictionaries is termed as examination of a witness who has already testified in order to check or discredit the witness testimony, knowledge or credibility. So it can be said that the main purpose of cross-examination is to elicit favorable facts from the witness or to impeach the credibility of the testifying witness so that the unfavorable testimony can be lessened. So cross-examination frequently produces critical evidence in trials, especially if a witness contradicts previous testimony. So it can be said that cross-examination is a key component in a trial and is one of the most efficient method of establishing truth and exposing falsehood. So it is important to note that the cross-examination is a part of the requirement of natural justice. So request for cross-examination of the witness whose statements are relied upon, if not accepted by the authority, would tantamount to a violation of principles of natural justice. So it can be said that cross-examination is a valuable right of the accused. So in short, to summarize, it can be said that if the benefit or the right to cross-examine the witness is not allowed by the appellate authority, then the same would lead to denial of natural justice. So moving on to the next slide. As you can see the screen, the present slide highlights the appellate mechanism under GST. So basically, there are four appeal stages as provided under the GST legislation. So as you can see the table, under stage 1, an order passed by an adjudicating authority can be appealed before the appellate authority, and such appeal can be filed by the commissioner or the aggrieved person. So relevant provisions with regard to appeal to appellate authority under GST have been provided under section 107 of the CGST Act and Rule 108 to 109A of the CGST rules. So thereafter, under stage 2, an appeal against the order passed by the appellate authority can be filed before the appellate tribunal, and such appeal can be filed by the commissioner or the aggrieved person. So appellate authority का जो भी order होगा, अगर aggrieved person को उसके against एक appeal file करनी है, then वो appeal appellate tribunal के सामने file होगी और वो appeal एक commissioner और aggrieved person file कर सकता है. So relevant provisions with regard to appeal to appellate tribunal have been provided under section 109 to section 1114 of the CGST Act. And reference can also be made to Rule 110 to 113 of the CGST rules. So thereafter, under stage 3 and stage 4, appeals can be filed by the aggrieved person before the High Court and Supreme Court. So in this regard, reference can be made to appeal to Section 117 and Section 118 of the CGST Act, which deals with appeal provisions related to High Court and Supreme Court. So, as I just discussed, an order passed by the adjudicating authority can be appealed before the appellate authority, and such appeal can be filed either by the commissioner or the aggrieved person. So, provisions related to appeal to appellate authority have been provided under Section 107 of the CGST Act. So, subsection 1 of Section 107 prescribes the time limit for filing an appeal. So, any person aggrieved by any decision or order passed under the CGST Act or SGST Act or the UTGST Act by an adjudicating authority may appeal to the prescribed appellate authority. So, such appeal is to be filed within 3 months from the date on which the said order or decision is communicated to such person. So, therefore, as per Section 107, subsection 1, a time limit of 3 months has been provided to file an appeal before the appellate authority against the order of an adjudicating authority. So the term adjudicating authority has been defined under subsection 2 of subsection 4 of section 2 of the CGST Act. So adjudicating authority means any authority appointed or authorized to pass an order or decision under this act. So any authority which has been appointed or authorized to pass an order or a decision under this act shall be construed as an adjudicating authority. However, such authority does not include the Central Board of Indirect Taxes and Customs, the Revisional Authority, the Authority for Advanced Ruling, the Appellate Authority for Advanced Ruling, the National Appellate Authority for Advanced Ruling, and the Appellate Tribunal, and the authority referred in subsection 2 of Section 171 of the CGST Act. Further, the term appellant authority has been defined under subsection 8 of Section 2 of the CGST Act, which means an authority appointed or authorized to hear appeals as referred to in Section 107 of the CGST Act. So, under subsection 1 of Section 107, the appellate authority has been prescribed before which appeals can be filed. So, in this regard, reference can be made to Rule 109A, Sub-Rule 1 of the CGST rules, which prescribes that the appellate authority before which an appeal against the order of the adjudicating authority can be filed. So basically, Rule 109A, Sub-Rule 1 प्रिस्क्राइब करता है appellate authority जिसके सामने एक अपील फाइल हो सकती है against the order passed by the adjudicating authority. So, in case a decision or an order is passed by the additional or joint commissioner, then the appeal shall be filed before the commissioner appeals. And where a decision or order is passed by the deputy or assistant commissioner or superintendent, then appeal shall be filed before any officer, but not below the rank of joint commissioner appeals. So in nutshell, an appeal against the order of the adjudicating authority is to be filed within 3 months, either before the commissioner appeals or the joint commissioner appeals, as the case may be. So, subsection 4 of Section 107 of the CGST Act provides the provisions related to condonation of delay in filing of appeal. So, power has been provided to the appellate authority to condone the delay in filing an appeal. So, the appellate authority may, if satisfied that the appellant was prevented by a sufficient cause from filing the appeal within the prescribed period, then such appellate authority shall condone the delay in filing of the appeal within a further period of 1 month. So therefore, the appellate authority can condone the delay in filing an appeal, provided it is provided that the appellant was prevented by a sufficient cause from filing the appeal within the prescribed time period. So further, subsection 5 of section 107 is a very important provision which deals with the provisions with regard to procedural aspects for filing appeal before the appellate authority. So in this regard, a reference can be made to Rule 108 of the CGST rules, which prescribes the form, manner, and the manner in which an appeal is to be filed before the appellate authority. So an appeal to the appellate authority shall be filed in form GST APL 01 along with the relevant documents either electronically or otherwise as notified. So appellate authority के आगे जो भी appeal file होगी उसका जो relevant form है वो है form GST APL 01 and वो appeal relevant documents के साथ file होगी either electronically or from any other procedure as notified. So once an appeal is filed on the GST portal, a provisional acknowledgement shall be issued to the appellant immediately. And the grounds of appeal and the form of verification shall also be filed along with the form GST APL 01. So once the appeal is filed and a provisional acknowledgement is issued, a certified copy of the decision or order appeal against shall be submitted within 7 days of filing the appeal. So upon filing of the such certified copy of the decision or order, a final acknowledgement indicating the appeal number shall be issued in form GST APL 02. So the appeal shall be treated as filed only when the final acknowledgement indicating the appeal number is issued. So here it is important to note that where the certified copy of the decision or order is submitted within 7 days from the date of filing the form GST APL 01, then the date of filing of the appeal shall be deemed to be the date of issue of the provisional acknowledgement. However, where the certified copy is submitted after 7 days, the date of filing of the appeal shall be the date of the submission of such certified copy. So the appeal shall be treated as filed only when the final acknowledgement indicating the appeal number has been issued to the assessee. So subsection 2 of section 107 prescribes the provisions related to departmental appeals. So that is the appeals which are filed by the tax authorities against the order of the adjudicating authority. So the commissioner has been given the power to direct any officer subordinate to him to file an appeal before the appellate authority. Such appeal is to be filed within 6 months from the date on which the said decision or order is communicated to such person. So therefore, a time limit of 6 months has been provided to the commissioner to file an appeal against the order of the adjudicating authority. So the procedural aspects with regard to filing of appeal by the tax authorities have been provided under Rule 109 of the CGST rules. So जो Rule 109 है वो प्रिस्क्राइब करता है फॉर्म एंड मैनर जिसमें अपील फाइल होगी बिफोर द appellate authority by the department. So an appeal to the appellate authority shall be filed by the tax authorities in form GST APL 03 along with the relevant documents. So such appeal shall be filed either electronically or as per the procedure notified. Suppose the filing of appeal in form GST APL 03, a certified copy of the decision or order appeal against shall be submitted within the period of 7 days of filing the appeal. So upon filing of such certified copies of the decision or order, the appeal number shall be issued to the tax department. So moving on to the next slide, as discussed earlier, the right to appeal is a substantive right, and the provisions of appeal under an enactment also places reasonable conditions such as mandatory pre-deposit of a certain sum before an appeal can be heard by the competent authority. So therefore, if right of appeal is subject to condition like pre-deposit of duty, then such right of appeal can be exercised only subject to such condition. So therefore, if an enactment contains the provision of pre-deposit, then such condition of pre-deposit has to be obliged before filing an appeal before the appellate authority. So under the GST Act, subsection 6 of section 107 prescribes the provisions related to pre-deposit. So as per subsection 6 of section 107 of the CGST Act, no appeal shall be filed unless the appellant has paid in full such part of the amount of tax, interest, fine, fee, and penalty arising from the impugned order as is admitted by him, and a sum equal to 10% of the remaining amount of tax in dispute arising from the said order, subject to a maximum of 25 crores in relation to which the appeal has been filed. So therefore, pre-deposit has been made a mandatory condition under the GST legislation as well. So for filing an appeal before the appellate authority, it has been prescribed that a sum equal to 10% of the amount of tax in dispute has to be deposited. However, such amount of pre-deposit shall not exceed rupees 25 crores. So, for example, a demand of tax of rupees 300 crores is confirmed against a registered person, and such demand is disputed by the registered person entirely. So, in such a scenario, while filing an appeal before the appellate authority, the registered person shall deposit rupees 25 crores and not 10% of 300 crores, since there has been a condition provided that maximum pre-deposit shall not exceed the amount of 25 crores. So further, once the appellant has paid the pre-deposit, then recovery proceedings for the balance disputed amount shall be deemed to be paid. Further, as per subsection 8 of section 107 of the Act, it has been provided that before passing an order, the appellate authority shall give a reasonable opportunity to the appellant of being heard. So therefore, कोई भी appellate authority एक order pass नहीं कर सकती without providing personal hearing to the appellant. अगर appellate authority एक order pass करती है without giving personal hearing to the appellant, then it can be very well argued that such order is bad in law, since the same has been passed in violation of the principles of natural justice. So therefore, the appellate authority is required to give an opportunity to the appellant of being heard. So the next provision deals with adjournment, which has been provided under subsection 9 of section 107 of the CGST Act. So in this regard, the appellate authority has been granted the power to provide adjournment to the appellant and the respondent. So such adjournment shall only be granted if sufficient cause is shown by the party requesting for adjournment of hearing. It is to be noted that no such adjournment shall be granted more than 3 times to a party during hearing of the appeal. So therefore, the appellate authority has the power to adjourn the hearing for a maximum of 3 times. So the next slide deals with the power of the appellate authority, which have been provided under subsection 10 and subsection 11 of the CGS of section 107 of the CGST Act. So the appellate authority may, at the time of hearing an appeal, allow an appellant to add any ground of appeal not specified in the grounds of appeal. So so the appellate authority can only allow such condition if it is satisfied that the omission of that ground from the grounds of appeal was not willful or unreasonable. So therefore, the appellate authority, the appellant may add any ground of appeal at the time of hearing, provided that the appellate authority is satisfied that the omission of that grounds from the grounds of appeal was not willful or unreasonable. Furthermore, the appellate authority has also been provided with the power to confirm, modify the decision, the order which the appellant has filed, for which an appeal has been filed by the appellant. However, the appellate authority shall not refer the case back to the adjudicating authority that passed the said decision or order. So, in a nutshell, the appellate authority has the power to allow the appellant to add any ground of appeal during the time of hearing, and it also has the power to confirm or modify the order of the adjudicating authority which has been filed for which an appeal has been filed by the aggrieved person. However, the appellate authority shall not remand back the case to the adjudicating authority that passed the earlier decision or the order. So moving on, as you can see the screen, subsection 12 to subsection 16 of section 107 are general provisions related to appeals before the appellate authority. So the order of the appellate authority disposing the appeal shall be in writing and shall clearly state the points for determination for the determination for determining the decision and the reasons for such decision. So basically, the order which will be passed by the appellate authority shall be in writing and shall clearly state the points of the decision and reasons for such decision. So further, a time limit has been prescribed to appellate authority for passing an order. So the appellate authority shall, where it is possible to do so, hear and decide every appeal within a period of 1 year from the date on which it is filed. So basically, the appellate authority has been provided a period of 1 year to pass an order for which an appeal has been filed by the aggrieved person. So on disposal of the appeal, the appellate authority shall communicate the order passed by it to the appellant, respondent, and also to the adjudicating authority. Further, subsection 16 of section 107 of the CGST Act provides that the order passed by the appellate authority shall be final and binding on the parties. So basically, all the provisions related to appeals before the appellate authority have been provided under section 107 of the CGST Act. So moving on, subsection 1 of section 108 of the CGST Act deals with the circumstances for which deals with the circumstances uh, uh, and revision of order and decision by the revisional authority. It also deals with the power which have been provided under the CGST Act to the revisional authority. So revisional authority has been defined under subsection 9 of section 2 of the CGST Act, which means an authority appointed or authorized for revision of a decision or orders referred to in section 108 of the CGST Act. So the powers that have been provided to the revisional authority is that the revisional authority can either suo motu or on the request of Commissioner of State Tax or Union Territory Tax shall call and examine the record of any proceeding if he considers that the order passed by any officer subordinate to him is erroneous insofar as it is prejudicial to the interest of the revenue, such order is illegal or improper or has been taken into account certain material facts. Further, the revisional authority has been provided with the power to stay the operation of a decision for such period as such authority may deem fit and can also make inquiry and modify the decision made by the officer subordinate to him. So as per Rule 109B of the CGST rules, where the revisional authority decides to pass an order in revision to the main order under section 108, and it is likely to affect the person adversely, then the revisional authority shall serve on him a notice in form GST RVN 01 and shall also give him a reasonable opportunity of being heard. Further, the revisional authority shall, along with its order under subsection 1 of section 108, shall issue a summary of the order in form GST APL 04, clearly indicating the final amount of demand confirmed against the assessee. It is important to note that that as per subsection 2 of section 108, the revisional authority shall not exercise any power under subsection 1 of subsection 108 if the order has been subject to an appeal to the appellate authority, appellate tribunal, high court, or the Supreme Court. So therefore, the revisional authority shall not be able to revise or enhance the order if such order is a subject matter of an appeal before the appellate authority, appellate tribunal, high court, or the Supreme Court. Further, the revisional authority shall not exercise such powers in case the period specified under section 1072 has not expired. That is, appeal can be filed, that is, appeal can still be filed before the appellate authority and the time limit of filing appeal has not been expired. Furthermore, the revisional authority shall not exercise any power which has been provided under subsection 1 of section 108 if the order has been already taken for revision under this section at an earlier stage. So further, every order passed by the revisional authority shall be subject to the provisions of section 113 and section 117 and 118, and the same shall be final and binding on the parties. So moving on to the next topic, as I had stated earlier, that under stage 2 of the appellate mechanism, an appeal against the order passed by the appellate authority can be filed before the appellate tribunal. So such appeal can be filed by the commissioner or the aggrieved person. Relevant provisions with regard to the appeal to appellate tribunal have been provided under section 109 to section 114 of the CGST Act. So subsection 1 of section 112 prescribes the time limit for filing an appeal. So any person who has been aggrieved by any decision or order passed by an appellate authority or the revisional authority may appeal to the appellate tribunal, provided such appeal is filed within 3 months from the date on the communication of the decision to the aggrieved person. So basically, a time limit of 3 months has been provided to file an appeal before the appellate tribunal against the order of the appellate authority. So appellate tribunal has been defined under subsection 9 of section 2, which means the GST tribunal constituted under section 109 of the CGST Act. However, as per subsection 2 of section 112, the appellate tribunal may, in its discretion, refuse to admit any such appeal where the tax or input tax credit involved, or basically the amount of tax disputed, does not exceed 50,000 rupees. So basically, the appellate tribunal has the power to refuse the admission of appeal if the quantum of dispute is less than 50,000 rupees. So subsection 3 and 4 of section 112 prescribes the provisions related to departmental appeal, that is, appeal file, the provisions related to the appeals which are to be filed by the tax authorities against the order of the appellate authority or the revision authority. So the commissioner has been given the power to direct any officer subordinate to him to file an appeal before the appellate tribunal. So such appeal is to be filed within 6 months from the date on which the said decision or order is communicated to such person. So therefore, under subsection 3 and subsection 4, a time limit of 6 months has been provided to the commissioner to file an appeal against the order of the appellate authority or the revisional authority. So the procedural aspect with regard to filing of appeal by the tax authorities have been provided under Rule 111 of the CGST rules. So the said rules prescribes the form and manner in which an appeal is to be filed before the appellate tribunal by the tax authorities. So an appeal to the appellate tribunal shall be filed by the tax authorities in form GST APL 01 along with relevant documentations. So such appeal shall be filed either electronically or otherwise. So thereafter, a certified copy of the decision or order appeal against shall be submitted within 7 days of filing the appeal. So once the certified copy of decision or order is filed, then the appeal number shall be issued by the registrar. So the next slide deals with the provisions of filing of memorandum of cross objections and condonation of delay. So as per subsection 5 of section 112, on receipt of notice by the party against whom the appeal has been preferred, the said party shall submit a memorandum of cross objections within 45 days of the receipt of such notice. So, such memorandum of cross objections to the appellant tribunal shall be filed either electronically or otherwise, or as may be notified by the registrar. And such memorandum of cross objections shall be filed in form GST APL 06. Further, subsection 6 of CGST of section 112 of the Act prescribes the provisions related to condonation of delay in filing appeal. So, power has been provided to the appellate tribunal to condone the delay in filing an appeal. So, the appellate tribunal, if satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the prescribed period, shall allow the appellant to file the appeal within a further period of 3 months. So therefore, the appellant tribunal can condone the delay in filing an appeal, provided it is proved by the appellant that such delay was prevented by sufficient cause of filing the appeal. So the form, manner and fees for filing an appeal before the appellate tribunal has been provided under subsection 7 of section 112 of the CGST Act. So an appeal to the appellate tribunal shall be filed in form GST APL 05 along with relevant documentation, either electronically or otherwise as notified. So once an appeal is filed on the GST portal, a provisional acknowledgement shall be issued to the appellant immediately. So thereafter, a certified copy of the decision or the order is to be submitted within 7 days of filing the appeal. However, where the certified copy is submitted after 7 days, the date of filing of the appeal shall be the date of the submission of such certified copy. Furthermore, the fees for filing of appeal before the appellate tribunal has been prescribed as 1,000 rupees for every 1 lakh rupees of demand determined in the order for which an appeal has been filed, and the maximum appeal fees shall not exceed 25,000 rupees. So the CGST Act also prescribes provisions related to pre-deposit in case the appeal is filed before the appellate tribunal. So as per subsection 8 of section 112 of the Act, no appeal shall be filed unless the appellant has paid the full tax which has been admitted by him, a sum equal to 20% of the remaining amount of tax in dispute arising from the such order, subject to a maximum of 50 crore rupees. So therefore, pre-deposit has been made a mandatory condition under the GST legislation as well for filing an appeal before the tribunal. So it has been prescribed that for filing an appeal before the appellant tribunal, a sum equal to 20% of the amount of tax in dispute has to be deposited. However, such amount to be deposited shall not exceed 50 crore rupees. So here I would like to mention that the 20% of the pre-deposit amount is an additional amount to the 10% of the tax which was earlier deposited at the stage of first appeal. So further, once the appellant has paid the pre-deposit, then recovery proceedings for the balance disputed amount shall be deemed to be stayed. So the next slide deals with the power of the appellate tribunal which have been provided under subsection 1 and 3 of the subsection 1 and subsection 3 of section 113 of the CGST Act. So the appellate tribunal has been provided with the power to confirm, modify, annul the order, appeal against. So basically, an appellate tribunal can has the power to confirm, modify, or annul the order of the appellate authority. The appellate tribunal has also been provided the power to refer the case back to the adjudicating authority, the appellate authority, or the revision authority that passed the earlier order. Furthermore, under subsection 2 of section 113 of the CGST Act, the appellate tribunal has been granted the power to provide adjournment to the appellant and to the respondent. So such adjournment shall only be granted if sufficient cause is shown by the party requesting for adjournment of hearing. So it is to be noted that no such adjournment shall be granted more than 3 times to a party during hearing of the appeal. So therefore, the appellate tribunal can adjourn the hearing maximum of 3 times. So the next slide deals with subsection 4 to subsection 6 of the section 113 of CGST Act. These are basically general provisions related to the appeals before the appellate tribunal. So a time limit has been prescribed to appellate tribunal for passing an order against an appeal. So the appellate tribunal shall, where it is possible to do so, hear and decide every appeal within a period of 1 year from the date on which it is filed. So basically, the appellate tribunal, as far as possible, shall hear and decide every appeal within a period of 1 year from the date on which it is filed. And further on disposal of the appeal, the appellate tribunal shall communicate the order passed by it to the appellant, respondent, the adjudicating authority, the appellate authority, or the revision authority. Further, as per subsection 6 of section 113 of the CGST Act, the order passed by the appellate tribunal shall be final and binding on the parties. So these were the provisions with regard to appeals before the appellate tribunal under GST. So the next topic that we'll be discussing is appeal to High Court under GST. So section 117 of the CGST Act and Rule 114 deals with the provisions related to appeal to High Court under GST. So as per subsection 1 of section 117, any person aggrieved by any order passed by the state bench or area bench of the appellate tribunal may file an appeal to the High Court, and the High Court may admit such appeal if it is satisfied that the case involves a substantial question of law. So therefore, the High Court will only admit an appeal against the order of the appellate tribunal if it is satisfied that such case involves a substantial question of law. If the appeal, if the case doesn't involve a substantial question of law, then the High Court will not admit an appeal against the order of the tribunal. So subsection 2 of section 117 prescribes the time limit for filing appeal before the High Court. So an appeal shall be filed within a period of 180 days from the date on which the order appeal against is received by the aggrieved person, and it shall be filed in such form and verified in such manner as may be prescribed. So therefore, an appeal against the order of the appellate tribunal shall be filed within a period of 180 days from the date on which the order is received by the aggrieved person. Furthermore, the High Court may also entertain an appeal after the expiry of period of 180 days, provided it is satisfied that there was a sufficient cause for not filing the appeal within the prescribed time period. So Rule 114 of the CGST rules prescribes the form in which appeal shall be filed before the High Court. So an appeal to the High Court shall be filed in form GST APL 08, and the grounds of appeal and the form of verification as contained in form GST APL 08 shall be signed in the manner as prescribed under Rule 26. Furthermore, as per subsection 3 of section 117, where the High Court is satisfied that a substantial question of law is involved in any case, then it shall formulate that question and the appeal shall be heard only on that question so formulated. Further, the respondents at the hearing of appeal be allowed to argue that the case does not involve a substantial question of law. So furthermore, as per subsection 4, the High Court shall decide the question of law so formulated and shall deliver such judgment thereon containing the grounds on which such decision is founded and may also award such cost as it may deem fit. So the High Court has also been provided the power to determine any issue which has not been determined by the state bench or the area bench. It has also been provided with the power to determine any issue which has been wrongly determined by the tribunal of a decision which involves substantial question of law as referred in subsection 3 of section 117. So section 118 of the CGST Act deals with the appeals provisions to the provisions related to appeals before the Supreme Court. So as per subsection 1 of section 118, an appeal shall lie to the Supreme Court from any order passed by the national bench or regional bench of the appellate tribunal. So basically, an appeal against the order passed by the national bench or the regional bench of the appellate tribunal can be filed before the Supreme Court. So from any judgment or order passed by the High Court, an appeal made under section 117 in any case, so basically there are two appeals that can be filed before the Supreme Court. Firstly, against the judgment of the High Court and from any order which has been passed by the national bench or the regional bench of the appellate tribunal. So the last topic that I would be discussing is some relevant provisions with regard to appeals under GST. So section 115 of the CGST Act prescribes the interest on refund of amount paid for admission of appeal. So where an amount paid by the appellant as a pre-deposit before the appellant authority or appellant tribunal is required to be refunded consequent of any order which is passed by the appellate authority or appellate tribunal shall be refunded along with interest as per the rate specified under section 56. So basically, in case a judgment is passed by the appellate authority or appellate tribunal in favor of the cessee, then the pre-deposit amount shall be refunded along with the payment of interest, and such interest shall be calculated from the date of payment of the amount till the date of refund of such amount. So furthermore, another important section is section 122 of the CGST Act, which deals with non-appealable decisions and order. So basically, no appeal shall lie against any decision taken or order passed by an officer of central tax if such decision taken or order passed relates to any one or more of the following matters. So an order of the commissioner or other authority empowered to direct transfer of proceedings from one officer to another. So an order sanctioning prosecution under this act, an order passed under section 80 of the act. So these are the provisions against which an order shall not be filed under the GST Act. So to conclude, I would say that an appeal is something that allows the aggrieved party to state facts which would have proved the already issued order incorrect and will provide relief as desired by the aggrieved party. So therefore, I would recommend that appeals should be drafted with utmost care, covering all the important facts and grounds. So trust the presentation was informative. For any clarification, you may please note down my contact details. Thank you.
Thank you, sir. So now I would like to hand over this to Pranshu sir.
Thank you so much. Thank you so much, Sarthak, for such a informative slides deck and sharing the key provisions under the GST law for
Thank you.
appeals and review. Thank you, Raj Chawla ji, for giving me this opportunity for sharing the art of drafting appeal under income tax law. And thank you, CA RK Bhalla ji and Asim Chawla ji, for all the guidance and blessings you have always showered on us. So today's topic is art of drafting appeals. I still remember my early days when I started my journey in tax laws. I had a bit of knowledge about tax, but about appeals, about review, I had a very little knowledge. I only had some basics about assessments, and I have never done any appeal at my young stage when I joined Mr. Chawla, Asim Chawla ji. And from there till now, 10 years being passed, and I have seen many briefs. I have gone through many briefs, and I have learned a lot. I have learned from many seniors, from many lawyers, from many senior counsels. So every person or every lawyer or every chartered accountant has a different art of drafting an appeal. And trust me, every CIT appeal or every other bench or honorable members in ITAT also have a different perspective to every brief, have a different perspective towards your paper books, your written submissions. And hence, at times, it gets important to understand your reader. For us, our readers are CIT appeal and honorable members sitting on the bench, whether it's ITAT or Honorable High Court or Supreme Court. And hence, it becomes all the more important for all of us to understand. And that's why, the drafting appeal is not a science. Also, we have codified law, that is a procedural law. But drafting appeal, drafting your submissions is not a science as such. It is an art. At the end of the day, all you want for your clients is to convince the other side that what you have stated on your piece of paper is the truth and is the only truth. And hence, the case has to be looked only from that very angle. And there is no other angle or there is no other interpretation to the law other than the one you have presented on your piece of paper. And hence, with this, I'll start to take you through different provisions of the Income Tax Act. Though the deck is there, Mr. Chawla would share this deck with you, and you can go through it with the relevant provisions under the income tax law. So I will not focus more on the provisions, but I would more focus on the practical aspect of it, what I have seen through my journey, and what key tips I have learned. I will share those with you. So now, even in cricket, we have, the DRS system. So in tax laws or in any other law, the appellate system is very much there because the human error or differentiation in interpretation of law cannot be ruled out. And hence, appeal has its own importance in every other field. But is it an inherent right? No, it is not an inherent right. If you come and say whether I can appeal, I have received this order and can I appeal? No, not really. You have to check the relevant provisions under the law whether you are eligible to appeal on such order, on such intimation or not. Under Income Tax Act, we have four stages. First is your original assessment proceedings, your penalty proceedings, your rectification orders, etc. Then comes your Commissioner Income Tax Appeal stage. If you are aggrieved by any order of assessing officer, you go to CIT Appeal. If you are aggrieved by CIT Appeal, or if the assessing officer is aggrieved by CIT Appeal, though there are certain limits assigned, you can approach or knock the door of Honorable Income Tax Appellate Tribunal. And if you are aggrieved by the order of Honorable Income Tax Appellate Tribunal, you can appear before Honorable High Court or Honorable Supreme Court. But you have to note one thing here. You can only knock the door of Honorable High Court or Supreme Court only on substantial question of law. Income Tax Appellate Tribunal is the last fact-finding body under this hierarchy of appellate system under income tax law. So if you want any facts, if you have missed any facts, you want to present it, this is the last body where you can present all your facts. So first we'll start with CIT appeal. Now everything is going faceless. You can't FaceTime now with your CIT appeal because you will not know who is the CIT appeal to which you have appealed. Even in pending matters, even in matters where hearings have been concluded, you were waiting for your orders, all have gone faceless. Hearings will again happen. You will receive notice on your portal e-proceeding tab, and so now everything is faceless. Everything depends upon what you write on the piece of paper and what you're presenting, because you can't explain. So that is why we thought of bringing this a small or brief webinar on art of drafting appeals, because going forward we are sitting in February. March is the time barring for assessments, and you receive all your orders and you have to file your appeals by April. And one should be aware that now in this scenario, when everything has gone faceless, your drafting is the key. Now everything what you put on the papers would be the only best friend you have, because CIT appeal would read it, would decide it on that basis and give you the order. So if you're writing brief clearly in a well presented manner, you'll get the success. तो जैसे स्कूल में हमें बताते थे ना, हैंड राइटिंग अच्छी होगी तो हैंड राइटिंग के 5 नंबर तो और भी मिल जाएंगे. So that's how this whole process would now work. The way you present, जितना सुंदर पेपर पे होगा उतना अच्छा रिजल्ट आने के चांसेस हैं. So whether every order is appealable? No, every other order is not appealable. Section 246A of the Income Tax Act provides those orders, those sections, orders passed under those sections are only appealable before CIT appeal. So supposedly under Section 246A, if you receive an order and which is not an appealable order under Section 246A, what can you do? In such a scenario, you can approach Honorable High Court by filing a writ petition under Article 226 of the Constitution of India. That right is still there. So even if you cannot approach CIT appeal, you can directly approach Honorable High Court and ask for the redressal of your averments and give your submissions before the Honorable High Court. So this is a small case study which we have prepared. So let's suppose there is a search matter happened in Chandigarh at Mr. X premises, and there's a connected search also happened under Section 132 of Income Tax Act at Mr. Y premises in New Delhi. And now the CIT centralizes the matter of Mr. Y at Chandigarh and passes an order under Section 127. Order under Section 127 is not an appealable order under Section 246A of the Act. And hence, in such a scenario, you cannot file an appeal before CIT appeal. You have to approach Honorable High Court by filing a writ petition, getting it quashed, or Honorable High Court directing the CIT to amend its order under Section 127. So there can be different scenarios under which a order, a direction, or intimation, or a letter received from assessing officer is not an appealable. So before filing an appeal, go through Section 246A of the Act. Now, is there any time limit to file an appeal? Yes. And now it has become all the more important. For the last bullet, you have to read for that. So we have 30 days time period to file an appeal, and that 30 days starts from the date of service of the assessment order or penalty order or any other appealable order. I would rather put it that way. From the date of service, and now everything has gone faceless. Your income tax assessments are now faceless. So in that scenario, how 30 days would be counted? Amendment was made under Rule 127, 127A, Section 282, 282A of the Act. And if you read section and rule together with notification number 4 of 2017, you'll realize that once the order is appearing in your e-proceeding tab on the portal, once you log in and you can see the order, from that very day, the time period of 30 days starts ticking in. So if you are representing your clients on for assessment proceedings, if you are aware that certain assessment proceedings are going on, please go have a check, have a look every alternate day whether the proceedings have been closed or whether the assessment order has been received, because 30 days time period would now start and you cannot go and complain or file a petition or file an application that we didn't receive the order or we didn't get a hard copy or we didn't receive any email, because once it is uploaded on the e-proceeding tab, 30 days time period would start. Now supposedly for sufficient reasons, maybe the council is not well or maybe the SSA is not well, we are into tough times and we have to be empathetical towards the medical emergency which is going on. For some reason there is a delay, then whether my appeal, I have lost the hope, I can't file an appeal, or still there is a possibility I can file. Yes, you can file, but along with the filing of an appeal, you have to file an application for condonation of delay. So when you draft your application for condonation of delay, keep it short, keep it simple, and clearly state the reasons why your appeal is delayed. Also mention the number of days by which the delay has happened and clearly specify the reasons. You need not specify the reasons for each and every day, but you just have to generally or clearly specify the reasons for the delay. And if possible, supposedly if the counsel is not well, try to attach doctor certificate, try to attach any prescription or try to attach any report or certified. This will not only enhance the value of your application, but once in such a faceless regime, once a CIT appeal would go through your application along with your attachment or affidavit, he would clearly understand that okay, this is a genuine case and there were sufficient reasons for not filing the appeal in time, and hence he can condone the delay and he can accept the appeal. Now, how to file an appeal before CIT appeal? Again, the process is all online, and I will come back to it. Whether it is a good system or whether it is a bad system, that is a matter of discussion at some other point in time. We'll do that. Everything is online. You file your appeal online. You go to your portal. You log in with your PAN number and password, and then you go for e-filing other forms, and you have Form 35 there. Like ITRs, we do not have an offline utility available. We do not have any other softwares for filing Form 35. So we have to do it through the online utility only. So that this is an online fillable form as per section 249 read with rule 45 and 46 of the income tax rules. You have to fill Form 35 there. You can save the draft and you can file later. Form 35 asks a lot of information about your tax, your return acknowledgement number, amount of tax you have paid, whether any other appeal is pending or not, whether you are filing any application for condonation delay, and you can just fill it completely. You keep your details handy and you can fill it. Now, for filing the appeal, you need to pay a certain fee. That fee is provided under section 249 subsection 1, that ranges from 250 rupees to 1000 rupees for CIT appeal for different assessments or for different amount of income tax return you have filed. So you can go through section 249 subsection 1 and you can decide how much amount you have to pay. Now the catch is how to pay that amount. So this amount will be paid through your normal challan, your income tax challan, IETNS. But while filing that tax, please be mindful of the fact that it has to be paid under self-assessment tax and not regular assessment tax. So pay it under self-assessment tax, and you have to fill the amount in others column and not in income tax column. I myself have witnessed a lot of objections coming in many appeals where the SSC has inadvertently paid the appellate fees under income tax column and not under others column. So be mindful of that. Now, Form 35 includes statement of facts and grounds of appeal. Most important statement of facts and grounds of appeal are most important, and how they should be drafted, we'll go through it in our next slides. Along with Form 35, there is an option of attachments which is available. So you have to attach your demand notice under section 156. You have to attach your assessment order copy, and apart from that, there is a column others for attachment. I personally recommend, and I personally for my clients do attach the copy of the challan of the appellate fees, and along with that I also prepare statement of facts and grounds of appeal separately, get it signed, scanned, and attach it in that others column. Although in Form 35 you can fill it, but still I would recommend you to separately also attach it. The form has to be e-verified and signed with digital signature. Who will sign? Whether a chartered accountant or an advocate can sign? No, he cannot. Only a person who is authorized under section 140 of the Income Tax Act can only sign Form 35. So there are few case laws which deal with it. Now, I personally feel they are not much of relevance in the online scenario, because in offline scenario, okay, we used to sign, chartered accountants and advocate used to sign on behalf of the clients, but in online scenarios, your DSCs are registered with your PAN numbers, and hence I don't think so any other person can sign the appeal until his DSC is registered with that. So now comes a statement of facts. Why statement of facts is most important, and I have seen people taking it very lightly. So when we file appeal, I have seen many people writing as per assessment records or as per assessment order. We are missing an opportunity here. We are missing an opportunity to tell the CIT appeal what we want to tell. If we write as per assessment records or as per assessment order, he would go through the assessment order and he would understand what the assessing officer was trying to tell him. As per the statement of facts, our facts should be clearly presented in pointers. Avoid writing in paragraphs. Write clearly in points, number them, divide your facts, and I'm only talking about facts, no arguments, no submissions, no case laws, pure facts. Start from day one. You receive notice under section 143(2) of that. Then you received 142(1) notice. You given the submission on this date. He asked this, you gave this. He asked that, you gave this. And then conclude with that he made an addition. Instead, you have this averment, and hence you are placing this appeal before Honorable CIT appeal. As simple as that. We need to understand that statement of facts are not grounds. Statement of facts are not arguments, and statement of facts are not our submissions. Facts should be simple, precise, clear. And if there is any mistake by assessing officer in assessment order, highlight it in your statement of facts. If any error has been made by you, you can cover that in your statement of facts. And hence, statement of facts is very important. If you also need to bring any new fact on the table, bring it through statement of facts. Because the moment CIT appeal would hold your Form 35, he would go through first statement of facts. Next come grounds of appeal. In faceless scheme, grounds are now the second most important aspect before your submissions, because this will lay down the road for your appeal. Not only before CIT appeal, but before ITAT, before Honorable High Court, and going forward. So, statement of facts, you cannot file before ITAT. You can only file before CIT appeal, and hence statement of facts also are important because they lay down the path for you till ITAT and High Court. and then grounds of appeal. So we need to understand that grounds of appeal are not facts. Statement of fact is different and ground of appeal is different. And through grounds of appeal, we are communicating and ensuring that, okay, we are aggrieved with the order of assessing officer, and hence we are coming to you with these grievances. They should be large in the ambit, as large as possible, so that many arguments can fit in one ground. You need to understand that there's a difference between grounds and arguments and submissions. Your ground should be large as possible, simple, clear, short, large, so as to cover many submissions. So you can have many different arguments under one single ground. So ground should be serially numbered. You need to have separate grounds for each or a different issue or addition which has happened. Uh, because if you're tallying the number of additions which has happened in long orders where there are 50, 60 odd additions, it is pretty much difficult to keep a track, and hence have different grounds for different additions. Though the addition might be similar, but still, though this is repetitive, but still, for sake of convenience for yourselves and for CIT appeal, you need to have different grounds if there are too many additions in your assessment order. Avoid referring case laws. I have seen certain briefs when we appear before ITAT, we receive briefs, and we have seen that the grounds have case laws. Our grounds are not ground; they are arguments or facts, and hence we need to revise those grounds before presenting the matter towards ITAT, because we do not want to restrict our scope. If we are mentioning any case law, or if we are mentioning any particular fact, we are restricting our scope in our arguments. That we can't do. That would hamper our submissions before CIT appeal or honorable ITAT. So these are some specimen grounds which I have noted for all of you. So first ground, always remember, first ground should be a general ground, challenging the total edition and complete order. If at any point in time you fall short of any ground, or if you fall prey to anything else, you can always fall back upon your general ground that, okay, this covers me. So this is a kind of a hack or a trick. So always take a general specific ground covering the whole order and the whole edition. Second, this is a specimen legal ground. Supposedly, the order has been passed without issuing a notice under section 132, 143.2 of that. So, what ground you can take in such a scenario? It should be simple, crisp, uh, and precise. You need not write the whole statement that he should have issued me a notice under section 143.2 and he has not issued, and hence since he has not issued, it is bad in law, etc., etc. Just write it simple. All these things, the whole detail, the whole arguments with all case laws should come in your submission and not in your ground. Then supposedly addition or disallowances has been made under section 37 being a personal expenditure. Now, the ground which we have taken here, if you read the first bullet, it is that on facts and circumstances of the case and in law, the disallowances amounting to 5 lakh under section 37 1 of the Act is bad in law and void ab initio. Now, here I can take multiple arguments while I am drafting my submissions. I can say, okay, it is not a personal expenditure. It is also not a capital expenditure. And hence, and this expense is specifically for business purpose. So all these three arguments, now I can fall and I can make them fall under this ground. Supposedly, I would have taken a ground that on facts and circumstances of the case, the disallowance amounting to 5 lakh is bad in law because it is not a personal expenditure. Then my arguments restrict to that specific point only. I am restricting my submissions in that scenario. So whenever you're drafting a ground, have a wholesome approach, have a holistic approach, and try to make it as wide as possible. As Balaji said, natural justice is most important. As he said that always try to take ground for natural justice. So this is a specimen. In my view, in my humble view, if there is no point, if you go through your order and if you have appeared in your assessment proceeding, and since assessment proceedings are now on all faceless on online, if you have not been on the bad side of natural justice, in the sense that if the assessing officer was fair and if he has given you enough time and opportunity, uh, avoid taking such a ground at times. But if you think no, that yes, I should have given some opportunity, you can very well take. Personally speaking, we try to take it in every other possible appeal, as Balaji said, but where it is very much crystal clear, we avoid it, because we have seen that at times of filing submissions, we fall short of our submissions. We don't generally have any material from the matter or from the brief to write on such grounds, and hence at times we do not press such grounds until unless there is a grave injustice happened. Then only CIT appeal and as well as honorable tribunal are eager to give you relief. But in small issues or scenarios, they will also not give you much relief on these points. Also, take a specimen residuary ground of appeal. Supposedly, you have missed taking a ground because we in 30 days we have to file an appeal. There's a lot of work, there's a lot of pressure. We have missed something, or we want to amend. We need to alter our ground. So always take a specimen residuary ground, which is the appellant craves leaves to add, alter, amend, or vary, withdraw any of the aforesaid ground of appeal. So this is the checklist for filing appeal before CIT appeal. So first of all, check whether the appeal lies. 246A, check the box. If it's okay, yes, appeal lies before CIT appeal. Go through your assessment order. Check if the order was passed, he had the jurisdiction to pass the order, whether the order was passed within limitation, whether you need to take any specific grounds for that, whether the order is time barred, or whether the order is passed without 143(2) notice, or whether the order has been on notice, has been issued on a non-existent entity. Take a wholesome approach on the jurisdiction aspect, because at times jurisdiction grounds also help you in getting the order quashed, being void ab initio. Then second tip I would give, check the computation, whether the tax has been calculated correctly on the edition, whether all your TDS credits have been given, whether the credit of all your advanced tax or self-assessment tax or regular assessment tax has been given, whether there is any issue in computation of interest under section 234B, C, A of that. And this is important. We once received a brief. It was a search matter, and we filed appeals for 6 years. And trust me, that was an error on our part. And that's how you learn. You make mistakes and then you grow. And then we realized we haven't checked the computation. When we checked the computation, there was a grave mistake in computation of 234B and C interest, and there was a huge refund which became due to the clients. We filed rectification under 154. We also took addition grounds, and we finally got the relief. But yes, we learned it. So whenever we received a brief, whenever we receive an order, we check the computations. Review assessment order for any other factual error you wish to draft a rectification application. Go through it. Don't wait. Even if you're filing an appeal, file a rectification application, because it anyways enhances your genuineness. And you can file that copy of 154 application also with CIT appeal with your submissions. It will enhance your proactiveness towards the matter. Draft your statement of facts, prepare grounds of appeal, pay your appeal fees, file online form 35, and sign it and send it online. Now lastly comes application for stay of demand. So AO has raised the demand, a hefty demand, a high pitch assessment, and now the challenge is you need to pay. There is a circular that you need to pay 20% of the demand if you have filed an appeal, and then you can get a stay. Whether that 20% is mandatory directory, we will cover all of this in last segment of our appeal of this deck. So representation before CIT appeal. Now what? We have filed an appeal. Now we are waiting for a call. So you will receive a notice on your e-proceeding tab. You will receive an email, and then you have to file your written submissions. Whether you can personally argue the matter before CIT appeal. In most of the cases, no, but in certain notified situations, only you can seek for a personal hearing, and that too would be through video conferencing only. That specific conditions are still not notified under the new faceless CIT appeal regime, and hence we are still waiting for that. But though whatever submissions we are currently filing before CIT appeal, we are taking a last resort, a residuary appeal we are making before CIT appeal, that we need a personal hearing before disposing of the matter. Because at times we have seen that the matters are complex, the transactions are complex. And with utmost respect to CIT appeal, with utmost respect to the tax officers and to the tax department, every person has its limitation to understand a specific accounting regime or specific tax matter or specific complex transactions. We as chartered accountants, we as lawyers also take time before drafting a submission. We have a lot of meetings with client understanding a specific issue and imagining or imagining CIT appeal who is above 50 years of age, just on the basis of your written submission, he understanding everything would be a bit difficult to fathom, and hence always try to take a plea of personal hearing, so that at least till last resort you can present your matter in a best possible manner. And if you do not get a personal hearing, always you have a ground of natural justice to take before Honorable ITAT that we sought a personal hearing but we were not given. So hence no opportunity was given to present the matter. So your written submissions should be clear, numbered properly. Every ground should be tackled separately. Starts with your background, your facts. You can replicate your statement of facts in your submissions. Link your background, your submission with paper book. What is paper book? Will come to it. All the documents on which you are placing reliance should be collated, compiled in form of a book. They should be serially numbered from 1, 2, 3, 4, 5. They should have an index, proper index, and that should be filed with your submissions. And in your submission, there should be a reference of the documents on which you are placing reliance on the submissions which have been placed before the AO. And hence everything should be well, correlated. So if he's reading your submission, he knows that he need to see page number this of paper book. So he will just flip the pages of the paper book and he'll go through it. Compared to a scenario where you are attaching annexures, different annexures, annexure A, B, C, and he is not aware even in annexure B which page he has to refer. Supposedly annexure B runs into 25 pages. To which page number he has to go, he is not aware because you have attached annexure A, B, C, D, E. So it's better you compile all your documents on which you are placing reliance, compile them, number them, prepare an index and attach with your submissions online. Your font size matters, and this is the practical aspect of it. I was representing a matter before Honorable CIT appeal, and he told me I used to use font 11 or font 12, and these were his words कि यार कुछ तो हम लोगों पे दया करो, हमारी एज तो देखा करो, कितना छोटा छोटा लिख के क्यों लाते हो. And that day I realized, and I have started using font 13 or font 14. So this is how you learn. These are the small practical tips. Now after using font 14, it's big font, easy to read, easy to go through. There is no strain on his eyes, no pressure. We have to make things as easy for the reader as possible. Last bullet, apart from your submissions, apart from your paper book, try to prepare a brief synopsis, 2 or 3 page synopsis which should be properly linked with your paper book with all the key documents. It may not have all your case laws referred, or it may only have the case laws number, if or the case law citations. But it should be as brief as possible so that anyone who can go through it, 2 3 pages, can get a hold of the matter, that okay, this matter pertains to these issues and this is the submission, and okay, this might possibly be the result. This would be very helpful in assisting CIT appeal while drafting the order. So when he's drafting the order, he knows he has a farra kind of thing in his hand, which is a 2 pager farra. He can go through it and he can refer all the pages which you have referred in that while drafting his order. So make things simple for him. So these are the sample submissions which we generally file before CIT appeal, and I thought it would be very necessary to bring this on this presentation deck. So if you see the first, we starts on the background, and that's how we number it: 1.1, 1.2, 1.3. We break our background, our facts, and then from point number 2 our submission starts. We first write the grounds which we have taken, and then our submissions on those grounds. And if you see the page numbers, we have linked our submissions with the pages of the paper book. We have made a mistake while drafting these grounds. We have taken too many grounds on a same issue. And then when we were drafting our submissions, we realized this mistake. And that's why we had to club all our grounds under one single submission. So we have clubbed ground number 3, 3.1, 3.2, 3.3, 3.4 all together while drafting the submissions. And hence, at times this happens. And as Mr. Asim Chavla also said, that we get very enthusiastic while drafting grounds of appeal and we take too many grounds. And then while drafting our submissions, we realize that, ye kya ho gaya? And hence, we need to focus on that also. Additional evidence, Shri C.A. Bhallaji also discussed about this in his keynote, Rule 46A of income tax. So if you have missed any evidence to place on record, or if you have missed any document or any fact to be placed on record before assessing officer, have you lost the opportunity, or can you do it before assessing officer? Yes, as per Rule 46A, you can do it before the assessing officer. But Rule 46A clearly lay down only 4 scenarios or conditions under which you can file an additional evidence. And hence, whenever you are preparing your application for admission of additional evidence, be mindful of quoting Rule 46A, and be mindful of the fact of quoting under which subsection or sub rule of Rule 46A you fall and why you fall it. So while drafting an application for additional evidence, specifically mention the reason why these documents could not be produced before assessing officer. A, whether he has rejected it, or whether he has not given you sufficient opportunity to present it, or whether you tried it and you could not present it, or whether you did not had those documents at that point in time in your possession. And if all these conditions fulfill, mention them. Try arranging, try attaching any other specific evidence to substantiate that fact along with your additional evidence, and then file an application for additional evidence. So Honorable High Court of Delhi in Text 100 India Private Limited 351 ITR 57 said that if there was a sufficient cause, the SSC could not produce the evidence, they should be accepted, because at the end of the day, as again Balaji said in Article 265 of the Constitution of India, the duty of the tax officer is to collect justified and correct taxes, and hence no one should be, feel the grievance. And hence, if we then wish to put any evidence on record, they should be allowed. But this is not as simple. We have personally seen in many matters where CIT appeal have rejected our application for additional evidence and they have not accepted. Though we have got this relief from ITAT has accepted those additional evidence, but why to have that? So next is additional grounds of appeal. Additional grounds basically are those grounds which you have missed taking while filing Form 35, or you have missed it in your grounds of appeal, and hence at a later stage while presenting the matter before appellate authority you realize okay you have missed, so you can take an additional ground. Section 250 subsection 5 of the act says that CIT appeal may allow taking a ground, extra ground or an additional ground if it was not missed, and if it was not willful or unreasonable of the part of SSE or not taking it at an earlier stage. So you have to state the reasons why it was not willful or unreasonable for you to take it. Generally, your additional grounds are accepted if it is a pure legal ground. If the facts, everything is on record, authorities are willing to take it on record. Jute Corporation of India, NTPC, Kanpur Coal Syndicates, these are few case laws of Honorable Supreme Court, wherein Honorable Supreme Court have clearly held number of times that the power of appellate authorities are coterminous with that of assessing authority, and hence additional grounds, even if not taken before the lower authorities, even if at ITAT level, if there is an additional ground which can be adjudicated on the basis of all the facts which are on present on the table, you should accept it and you should adjudicate on that grounds. Power of enhancement. This is really important in the sense that CIT appeal has power of enhancing the assessment. If assessing officer has made an addition and you have filed an appeal, CIT appeal has the power to enhance that assessment and make more addition to it. But whether that power is restricted to certain sense, yes. So as per the decision of Delhi High Court, CIT appeal can only enhance and can only invoke this power of enhancement only restricted to the additions which are made in the assessment order and only pertaining to the issues which are there in the assessment order. So CIT appeal cannot reinitiate your assessment. He cannot make roving and fishing inquiries. Whatever is there in your assessment order, he can only lay emphasis on it, and supposedly if the addition on a particular aspect. So let us suppose a ad hoc addition has been made by the assessing officer that you have not given bills and vouchers, and hence on that basis only 10% of the total expenditure has been added. CIT appeal can enhance it and say, no, if you have not given bill and vouchers, why 10%? Why not 100%? So this is the power to enhance, but he cannot go into a separate altogether, a different addition altogether, which never formed part of assessment order. So he has to restrict himself up to only the addition which is there in the assessment order. In such a scenario, at times we refrain from filing appeal. We present and we tell our clients that don't file appeal if the matter is pretty small, or if the issue is very very small, or the amount of addition is small, because the risk, or if we are aware that a certain major issue has skipped assessment, we would certainly say that pay your taxes, get rid of it. Why you want to risk the enhancement uh, issue? This has happened in one of our matters. Uh, a small addition was made of 20,000 rupees. Appeal was filed by the client. He forced, and then the matter was enhanced, and the addition was made by CIT appeal of 7.5 crores. So yes, this is a risk which you can't take. Other important points. This is very very important point. The first point. Of lately, we have seen that CIT appeals had some instructions and they were not adjudicating on legal grounds. Well settled legal grounds by Honorable Supreme Court, jurisdictional high courts. Your matter totally is covered by those case laws, but still, they would simply brush them away. They would not adjudicate on it. They would not give any finding. And when you receive your assessment order, You will receive only their discussion on your factual grounds, and they have brushed aside and they have not given any decision on your legal grounds. So, in such a scenario, you can file a rectification application before CIT appeal and can request that you have missed adjudicating these grounds and please adjudicate. Apart from that, also file an appeal before ITAT, but apart from that, also file a rectification application. This will save you from two things. When you will go before ITAT and you will take this ground, ITAT would say that why CIT appeal has not adjudicated, and you will have no answer. Then ITAT would say, okay, we are remanding this matter back to the files of CIT appeal, and then you would be stuck in this vicious circle of litigation. To avoid that, file a rectification application. You can present that rectification application before ITAT, and this will be very, very helpful for you. And there are many case laws which suggest that this is a mistake apparent from record, not adjudicating all the grounds, and hence you can file a rectification application. Appeal once filed cannot be withdrawn at the instance of SSC. So if you have filed an appeal to avoid your penalty and you go to CIT appeal and you request CIT appeal that, okay, please let me withdraw the appeal, sorry, it is only at the instance of CIT appeal. If CIT appeal wants, he can allow. If he doesn't want, he will not allow you. He will not give you the leave. Strict rule of evidence are not applicable to income tax matters. We are all are aware of that Evidence Act as such or Civil Procedure Code are as such not applicable to tax matters, but at times tax authorities do lay emphasis on Evidence Act or certain evidences, and we have also as councils and as chartered accountants have used Evidence Act in many of our matters. So in few matters, we received certain documents from assessing officer where the sign of our SSEs were there or the taxpayers were there. We took a report from a handwriting expert under section 45 of the Evidence Act, and we presented that on record and suggested that as per that report, the signatures do not match, and hence someone else has forged those signatures. And hence we have relied on a section of Evidence Act. We have relied on a report which is covered under that section, and hence, though Evidence Act as such clearly is not applicable in tax matters, but where necessary, you should invoke it. Next is Income Tax Appellate Tribunal. If you are aggrieved by an order of CIT appeal, or you got relief but the tax department is aggrieved by order of CIT appeal, you can knock the door of Honorable ITAT. Please help us. Before filing any appeal before ITAT, please read Income Tax Appellate Tribunal Rules 1963. These are separate rules. These are not income tax rules. These are separate tribunal rules. And these rules cover everything from your filing of your submission, from filing of your appeals to filing of your paper books, etc. Till your dress code also. So please read Income Tax Appellate Tribunal Rules 1963. So if Income Tax Department is aggrieved by any order of CIT appeal, they can approach and file an appeal before ITAT only and only if the tax effect is above 50 lakh rupees. It is tax effect. Tax effect doesn't include interest. So only if the tax effect is above 50 lakhs, they can approach and file an appeal before ITAT. SSC can approach and file an appeal before ITAT for any amount, for even a nil amount, if he is aggrieved or if there is certain issues involved. He can appeal directly before ITAT against order of CIT appeal, against order of Commissioner Income Tax under section 263, 12AA, 80G, or directions of dispute resolution panel. Is there any time limit to file an appeal? Yes. 60 days. Earlier we had 30 days in CIT appeal. Here we have 60 days. Again, we have to keep in mind CIT appeal is faceless. Please be mindful of these last bullet point. The day the order is appearing on the e-proceeding tab, the CIT appeal order, 60 days time period takes in. How to file an appeal? We do not have an online facility of filing an appeal before ITAT as of now, but the portal is ready. It may be inaugurated or initiated at any point in time. But currently you have to file appeal before ITAT in physical form in form number 36. Along with form number 36, you have to attach appellate fee challan that the fees structure differs from CIT appeal fee structure, and you have to read section 253 subsection 6 for that, for appeal fees. The catch remains the same. The appeal fees has to be deposited in the self-assessment tax others. In ITAT, if the challan is wrongly filed, your appeal would be objected and you have to get it rectified within 30 days of filing the appeal. And trust me, getting the challan rectified from AO is like running from here and there. So don't make that mistake. And appeal fees at ITAT sometimes go up to 10,000 rupees. So don't take that risk. Whenever instructing your clients, assessees, to pay appeal fees, make sure to tell them, please pay under self-assessment tax under others. Form 36 has to be attached with certified copies of CIT appeal order. Along with that, form 35 and all its attachment, certified notice of demand, certified assessment order or penalty order, or etc. And the challan, and a copy of the grounds which you are taking with form 36. So grounds of appeal also has to be prepared with form 36 and has to be attached. All the additions which have been sustained by CIT appeal and the grounds you are taking on that basis. While drafting grounds before ITAT, make sure that your averments clearly say about CIT appeal and not against assessing officer, because you are appealing before ITAT against order of CIT appeal and not against order of assessing officer. So if you are supposedly making a ground before CIT appeal that on the basis of facts and circumstances of the case, learned AO failed to take into cognizance. So before ITAT, you should instead write that on the basis of facts and circumstances of the case, learned AO and learned CIT appeal failed, or learned CIT appeal erred in confirming the addition of AO. So your ground should be slightly tweaked. You cannot copy and paste the grounds raised before CIT appeal simply before ITAT. So paper book has to be presented before ITAT. There is a specific rule, Rule 18 under ITAT rules regarding paper book and what all paper should be formed. So the Rule 18 says, as we discussed, that paper book should be properly compiled, page numbered, with index. There should be no additional evidence in the paper book. And there is a specific format, and you also have to give a certificate with the paper book. Your one point I missed, while filing appeal before ITAT, you have to prepare at least 4 sets. 3 sets have to be filed at ITAT, 2 for the honorable bench, 1 for the department representative, and 1 set for your own self. We generally prepare 5 sets, 1 for ourselves and 1 for the client also. Then same goes with paper book also. You have to prepare 5 sets. 3 sets have to be filed there and 2 for your own office copy. So this is the sample paper book which we prepare. So you have this index where you just write the brief particulars of the document which is placed in the paper book, the page number, and at last it is a certificate which you have to give. So this certificate is very important. If you do not give the certificate, your paper book would not be accepted before ITAT. So you certify that there is no additional evidence and all the documents which have been placed in the paper book have been filed either before the assessing officer or before the CIT appeal, and hence you are not filing any additional evidence. Next is cross objection. Interesting. What is cross objection? It is like a cross appeal. So supposedly you won at CIT appeal level. You took 4 arguments or 4 grounds, I would say. But what CIT appeal did, CIT appeal gave you relief only on the jurisdictional issue. But he rejected your appeal on the facts. But since you won on the jurisdictional issue, your appeal was allowed. And on that specific ground, assessing officer has appealed before ITAT. Now you receive from ITAT a letter informing that assessing officer has appealed against the order of CIT appeal, and hence, if you wish to file any cross objection, you can do that. You have 30 days time period to file a cross objection. What is a cross objection? Cross objection is basically a cross appeal. So although you got relief, although you need not file an appeal, but since your matter was dismissed on merits and you only got relief on jurisdictional ground, you need to take now an appeal on the merits of the case also. So supposedly you took a ground in CIT appeal that the order was passed without issuing notice under section 143(2) of that. And apart from that, you took another ground that the addition made under section 68 was bad in law, addition made under section 37(1) was bad in law. CIT appeal rejected all two grounds of 68 and 37(1), but he accepted your ground of section 143(2). Now AO appealed against that to ITAT that the CIT appeal erred in dismissing the appeal and giving the relief under 143(2) because notice was already issued under section 143(2) of that. So now in cross objection, you also have to prepare the cross objection grounds. These are similarly like grounds of appeal. You have to prepare cross objection grounds of appeal, wherein you have to take grounds pertaining to the additions on section 68, on section 37, which were sustained by CIT appeal. So this is nothing but a cross appeal. So this is the checklist for filing appeal before ITAT, similarly like CIT appeal. Paper book, time for filing paper book is minimum 7 days before the matter is listed for hearing. So if a matter is listed for hearing supposedly on X date, you have to file paper book minimum 7 days before that. You cannot file paper book on the day of the hearing because you have to give time to the department representative to go through that paper book. So additional evidence, similarly as rule 46A, we have rule 29. Similar replica, you can file an additional evidence before ITAT. You have to justify that what was the sufficient substantial cause, why it was not filed earlier. And you have to file an application, attach additional evidence, prepare a separate paper book for additional evidence as per rule 18 and attach it with your application and present it before the honorable bench. And then honorable bench may accept or reject it. And if they accept it, they have to record the reasons for accepting it in writing. Now the catch is avoid filing any additional evidence before ITAT. Try to do it everything before CIT appeal. Because if you file any additional evidence before ITAT, 99% your matter would be remanded back to the files of assessing officer or CIT appeal. So don't take that risk. If you do not want to enter into that vicious circle, try that everything is covered, well covered before CIT appeal. But if you have missed, then you can't do anything. ITAT is the last fact finding authority, and hence, if you clearly think no, this is very very important and I have to file it before ITAT because you will never get any opportunity after that. Additional grounds of appeal, you can take additional grounds of appeal also before ITAT. And in one of the matters, what happened, and we took resort to this decision of Mumbai Tribunal. So we reached till ITAT, and then our matter was remanded back to the files of CIT appeal. So we crossed one whole process, and then we came back to CIT appeal. And at CIT appeal, we realized that okay, we could have taken another ground, and we took that ground before CIT appeal. And 2 hearings we did only to convince CIT appeal that yes, we can take as per law additional ground even in the second round of appeal before CIT appeal. So you can go through this case law. So now here's the important thing: the representation before say IT80. Now, as presented in Union Budget 2021, even IT80 would go faceless. What would be the nuances of it? What would be the whole procedure of it? We are not sure. Currently, we are appearing before Honorable IT80 through video conferencing. So whenever you appear before IT80, you have to make sure that you follow the dress code. Dress code is mentioned in the rules. For men, you have a particular dress code. For women, you have a particular dress code. Please be mindful of that. You have to wear a coat, a tie, trousers, and for women, you also have the same thing, or your sari or your suit. Um, so it is not sure whether ITIT would only decide on the basis of written submissions or opportunity for personal hearing would be given. So we have to be prepared for the worst. And why do I say worst? Because this is the last fact-finding authority, and hence, if the right of personal hearing is taken away, it would be grave injustice to the whole system. Uh, because there are a lot of complex issues, and presenting everything on this single screen is not possible. And in one of the matters, we took printouts on the architect sheet size paper because we need to explain CIT appeal certain issues in the map, and because of which the addition of agriculture income or agriculture tax or agriculture land was made, and when we had to tell him exact location, all these we cannot present on this small screen at times. So yes, the effectiveness would go down, I feel, and hence art of presentation on a smaller sheet would crop in. Uh, Apart from paper book, always try to prepare a case law paper book separately. All the case laws on which you are relying, also please take a printout of them, prepare a separate paper book, number them, highlight them in your copy, the paragraph which you need to mention to the honorable bench, page number, write everything on the index, the page number of the paper book, case law paper book, the para number. So whenever you are giving arguments or whenever you are representing the matter before the honorable ITAT, you have everything handy, and you can take the honorable bench through everything in a single shot. Now, representing matter before ITAT is like a court. So you have you appearing for for your SSC, and then we have a department representative appearing for the department. If it's your appeal, you will get the first opportunity to present your arguments. Be polite towards the bench. Be cool. Be simple. Be soft. Don't be too loud. Don't be too fast like a train. Don't be too slow. Start in a chronological order. Start from your grounds of appeal in Form 36. Then take them through assessment order, what assessing officer said. Then what you presented before CIT appeal. Then what did CIT appeal said. And then what are your arguments or your argument before the honorable bench. Always try to mark everything in your copy. Highlight it, mark it, page it, number it, para it. So whenever you are taking the honorable bench, you are always handy of the page numbers, para numbers. Honorable bench, your lordship, para number 4 of page number 36. This is what assessing officer said. Page number 2 of para 36 of page number 8. CIT appeal order. This CIT appeal said. So everything should be well written with you. You should have everything so that you need not fumble at that point in time. Understand your bench. Some honorable members are more interested in factual aspects, some are more interested or keen in taking note of legal points. So try to find a judgment authored by them on the similar issue. That would be very, very helpful for you. Because if you find a judgment in your favor on the similar issue which is authored by them, then it somewhat becomes covered by it. So your matter becomes covered by it. So getting a relief would be quite easy in that scenario. What I do, I generally prepare I fold a A4 sheet, I tear it in half, and I prepare a single farra sort of thing uh, and I list all the page numbers of the paper book, all my submissions or my arguments in brief, the page numbers, and the case laws on which I have to place reliance. And I have this small farra which is ready in my hand. So whenever I'm making an argument, I just have to go through it and take my arguments. Okay, take. I have taken this. I have taken that. At times, you prepare in your mind how you want to take the bench through the matter. But when you start presenting the matter, honorable bench instead take hold of the matter and start taking you through everything. So your plan fails in such a scenario. So what should you do in that case? In that scenario, these small tips, small farra or small paper, or your pagination or your highlighting in your book would actually be very very helpful, because you would not fumble. As Asim Chawla ji said, and this is a very old saying, and he always used to tell me, Uttar, fact before act. If you are well versed with your facts, even if you are slightly, not aware of the act a bit, still, you have won the battle. You need to be on the top of your facts. So if everything is in your hand, you have won half the battle. Don't interrupt the other side or the honorable members in between. If they are telling you something or if the other person is arguing, let them argue. Once the department representative finish its argument, you would again be given a chance if you want to counter anything. Before Honorable ITAT, you can file also an application for early hearing. You can also approach Honorable Bench that, okay, please hear me out of turn, please fix my appeal. And generally, ITAT fix on out of turn basis if your case falls under these circumstances. If either the matter is squarely covered by your own matter of different year by another ITAT or by the Honorable High Court decision, or the matter is covered by another SSC's matter, same issue, or the matter is on a question of law which is well settled by Honorable High Court or Honorable Supreme Court, or if there is a huge demand or a high pitch assessment, but you are not seeking stay of demand but only requesting for early hearing. And if it is not prejudicial to the interest of revenue, generally Honorable Bench gives you early hearing. Now, this is the main thing, the application for stay of demand. There is a lot of confusion, and when I started my journey as a tax practitioner, I always used to get confused in this for some reason or the other, because so as simple it looks, it might not be as simple because of a lot of circulars coming in and a lot of amendments which have now happened. So you have received assessment order, a high pitch assessment has been made, and you receive demand notice. You do all your calculations on your computation and you realize that, okay, the tax amount is correct, but it is too huge for the assessee to pay. You have anyways filed appeal before Honorable CIT appeal. Now you have to pay the demand within 30 days as per section 226 and as per your demand notice. You move an application under section 220 subsection 6 before assessing officer to grant you stay of demand. Assessing officer rejects your application, or he says you that, okay, I'll give you stay of demand if you deposit 20% of your demand as per the circular dated 31st July 2017. Now, as per the circular, the norm is you pay 20% of your tax demand, and we'll give you kind of automatic stay. But he rejects it. You do not wish to pay 20% because, as per the decision of Honorable High Court in the case of LG Electronics and in the case of Flipkart, it was clearly laid down that this 20% limit is not mandatory and it is directory. So even in scenarios which need attention or where the case is prima facie in favor of the SSC, principal CIT or assessing officer can also reduce this 20% to nil. So hence the circular is directory, not mandatory. So AO rejects, you appear before principal CIT, place your arguments. Principal CIT also again tells you the same thing. Please go and deposit 20%. I'm not gonna give you any relief on the basis of LG Electronics or Flipkart. Then can you appear before CIT appeal and request? If you say theoretically, yes. As per law, yes. There are a lot of case laws also which says that you can appear before CIT appeal. You can file an application for uh, stay of demand before CIT appeal, but practically no CIT appeal would entertain it because principal CIT and general CIT appeal are at the same level. So no CIT appeal would cut or go against the orders of principal CIT. So in such a scenario, practically you have no other option left but to file a writ petition before Honorable High Court. You cannot approach IT80 in this regard. You can only approach IT80 for stay of demand only on the matters which were pending before Honorable IT80 or which are pending before Honorable IT80. If a matter is not pending before Honorable IT80, you cannot approach Honorable IT80 for stay of demand. And hence you have to approach Honorable High Court. If your matter is pending before CIT appeal, then for stay of demand you have to go to High Court. Now supposedly you go to IT80, you have not paid any penny yet, and your appeal is dismissed by CIT appeal, and then you approach IT80. Now you can approach, you can along with form 36 which you file the appellate form, you can also file application for stay of demand before IT80, and you can request for stay of demand. Now here's the catch. Amendment was moved under section 254 and a new proviso was added which says that IT80 can grant stay of demand up to 180 days subject to the condition that the assessee deposits not less than 20% of the amount of tax, interest and penalty or any other sum payable under the provisions of this act, or furnishes security of equal amount in respect thereof. Now, as Sarthak said, that there is a pre-deposit, mandatory pre-deposit under the GST law for filing appeal. So now, do we also have to interpret it in that way? Is it now compulsory or a mandatory pre-deposit of 20% to seek stay of demand? This question was referred to special bench IT80 Mumbai. In the case of Tata Trust approached honorable bench for stay of demand, and this was referred. But since the matter was already decided in the quantum, this reference was taken away from special bench, and hence we do not have any judicial guidance on it. But if you read, it appears on a plain reading of it that yes, this is now mandatory. You have to pay at least 20% in cash or through security. But if you go by the rules of interpretation and if you read in a wholesome manner, I feel honorable IT80 and courts should interpret it as if it is directory in nature and it is not mandatory. We have to see how courts interpret it, and then only we can go ahead. But in my personal research, I think it is directory and it is not mandatory. But that's all from my side for today on this little or brief discussion on art of drafting appeals under income tax law. We have not covered High Court and Supreme Court. We can do it in the next session because of the time constraint, or the matters before High Court or Supreme Court are at a different level altogether. And for all our CF eternities, CIT appeal and IT80 level is more important as we can't appear before Honorable High Court. So this is from my side. If you have any queries, questions, you need any assistance, I'm always available on email, on WhatsApp. These are my contacts details. Thank you so much. Thank you for your time, patience, and thank you for listening.
Tabla ji can't hear you. आपकी आवाज
मैं तो नहीं बोल रहा हूँ।
प्रांशु जी आवाज आ रही है अब?
आगे मैं आपको
ठीक है, तो अब हम क्वेरीज ले लेते हैं अपने मेंबर्स की एक एक करके। आप भी कमेंट बॉक्स देखते रहिएगा प्लीज। सबसे पहली साक्षी मुंजाल जी की क्वेरी है, हाय सर, वी हैव फाइल्ड अपील इन वेयर वी हैव नॉट गॉट एनी नोटिस इन दिस रिगार्ड। भल्ला साहब,
क्या चीज है यार, आज ये क्वेरी आ रही साइड में?
साक्षी मुंजाल जी की क्वेरी है, वी हैव फाइल्ड अपील इन जीएसटी चंडीगढ़ वेयर वी हैव नॉट गॉट एनी नोटिस इन दिस रिगार्ड।
You have filed an appeal in GST at Chandigarh,
हाँ जी,
and but you have not received any notice.
ठीक।
So what is query?
सार्थक जी, आप देख पा रहे क्वेरी?
नहीं,
कोई विजिबल नहीं है।
सर,
नोटिस नहीं मिला है।
438 पे साक्षी जी ने क्वेरी रेज की है।
सर, तो वो मेरे हिसाब से उस क्वेरी का आंसर ये है कि अभी उन्होंने अपील फाइल करी है एंड शी शुड वेट। जब वो अपील फिक्स हो जाएगी, शी विल रिसीव अ नोटिस ऑन द डेट ऑफ हियरिंग।
ठीक है
देन
सर।
शी हैज टू गो।
अच्छा, कमर मोदी जी की क्वेरी है, प्लीज शेयर ए स्पेसिमन ऑफ अपील एट, उन्होंने अपनी ईमेल आईडी दी है, तो मैं आपसे रिक्वेस्ट करूंगा कि आप प्लीज सर, क्या आप अपनी ईमेल आईडी शेयर करना चाहें तो कर लीजिए इनको, ये अमर मोदी जी आपको डायरेक्ट रिक्वेस्ट कर लेंगे। यू कैन प्लीज शेयर योर मोबाइल नंबर एंड ईमेल आईडी इफ यू वांट सो।
नहीं, यहाँ प्राइवेट चैट में आ जाना चाहिए ना।
कोई बात नहीं। सार्थक जी, वुड यू लाइक टू शेयर योर मोबाइल नंबर एंड ईमेल आईडी?
यस सर, मैंने इनफैक्ट प्रेजेंटेशन में शेयर था, या तो मैं आपको पीपीटी सर्कुलेट कर दूंगा सर, आप आगे फिर दे दीजिएगा।
कमेंट बॉक्स में डाल दीजिए ना अपना नाम और मोबाइल नंबर और ईमेल आईडी, आप दोनों लोग डाल दीजिए।
ठीक है सर, हम डाल देते हैं अभी।
ठीक है ना? अच्छा, साहिल ढींगरा जी की क्वेरी है, सेक्शन 250 नोटिस in form 35 also we mention section 246A 30 days from receipt of notice, no condition।
35 फॉर्म 35 फाइल करते हैं तो उसमें वो पूछता है अंडर विच सेक्शन यू आर अपीलिंग। उसमें ड्रॉप डाउन मेन्यू में स्पेशली सारे सेक्शंस मेंशन्ड हैं, सो यू हैव टू सिलेक्ट दैट पर्टिकुलर सेक्शन इन विच यू आर अपीलिंग। एंड कंडोनेशन का भी उसी में ऑप्शन है, उसमें पूरा आपको कंडोनेशन का डालना पड़ता है। if the appeal is late, you have to check the box and you have to fill your condonation application there।
ठीक है सर। ये सुधीर कटारिया जी की क्वेरी है, आई ट्राइड टू फाइल APL 01 फॉर गुड्स डिटेन्ड एट बॉर्डर, डिपार्टमेंट इशूड टेम्परेरी GST registration but it is not uploaded through EVC as well as through DSC, please let me know what to do।
नहीं, it is a matter of detention of the vehicle or goods
detained।
goods detained।
yes sir।
So they wanted to whether they have issued any order for payment।
मैं सुधीर कटियारा जी से रिक्वेस्ट करूंगा कि यू कैन डायरेक्टली कॉल आवर स्पीकर CA RK भल्ला जी और CA सार्थक गर्ग जी। भल्ला जी, you can share your mobile number so that Sudhir Kataria ji will call you।
My number is 9810067811। I repeat 9810067811। हम इनको बात कर ले, मैं आपको इसको क्लैरिफिकेशन दे दूंगा।
मैंने आपका मोबाइल नंबर कमेंट बॉक्स में डाल दिया है, तो सुधीर कटारिया जी, यू प्लीज नोट डाउन मोबाइल नंबर ऑफ अवर RK Balla ji। Next query is from Rahul Khanna, sir, in faceless appeal, is it good to file paper book before CIT appeals?
Yes, it is better to file paper book because you are not only preparing for CIT appeals, but somehow you are also preparing for ITAT. Once your paper book is prepared here, if your appeal is rejected, you always have everything now prepared with yourselves. You have nothing to do now। सब कुछ स्कैन आपके पास पड़ा है, आपको सिर्फ प्रिंट आउट निकालना है, पेजिनेशन पहले ही हो रखी है, आईटीटी के लिए आप रेडी हो।
ठीक है सर। So with this is the end of the queries, and now I want to thank first of all CA RK Bhallaji, our keynote speaker, and CA Asim Chawla ji in absentia for his guidance, and CA Sarthak Garg ji and CA Pranshu Goel ji, our young and dynamic speakers on GST and income tax. And also, I want to request, if you want to share your mobile number and email ID with our members, you can share it in the comment box, so that our members will directly contact with you in case of any query or for your PPT. So last query came again from Mr. Rahul Khanna. Sir, whether name of the client or AO should be mentioned in paper book?
So you have to anyways mention the name of the client. You have to mention the name of the PAN number, the year. AO, you are attaching the assessment order. In AO name is also visible to CIT appeal.
Okay, sir. So thank you all. Thank you very much. Thank you all the members attending this our webinar. Thank you very much.
Thank you so much.
Thank you. Thank you.